Good evening, everyone. Welcome and thank you for joining us for tonight's webinar on legal considerations post-COVID-19, estate planning, wills, wealth protection, family law, intellectual property, privacy and confidentiality, an initiative of the Queensland Regional Committee. I would like to acknowledge the traditional owners of country throughout Australia and recognise their continuing connection to land, waters and culture. I would also like to pay respect to the elders, both past and present and emerging. And together we restate our shared commitment to advancing Aboriginal, Torres Strait Islander and Maori health and education as core business of the college. The Professional Medical Practice, or PMP for short, is a collective of experts supporting the college through various events, providing financial well-being and business education for medical specialists. Tonight we are supported by some of these experts. Anthony Harrison and Rhys Williamson of Marnie's Lawyers and Advisors, Chris Mariani of Medical and General Risk Solutions, and Damien Greer from Damien Greer Lawyers joining us this evening. Carolyn Lopez, who is the Education, Events and Media Manager for the PMP, is also online with us. From RACP, we have Tracy Hanley, the Senior Executive Officer for Queensland, and Hannah Parker, Member Support Officer, online from the Queensland Regional Office to help with any questions you wish to submit through the Q&A function. I would like to now introduce our first presenter, Rhys Williamson. Rhys is an associate at Marnie's with experience assisting businesses with their commercial matters, including shareholder agreements, IP licensing, software licensing, and privacy issues. I will now hand over to you, Rhys.
Hey guys, thanks so much for that introduction. As you're aware, I'm an associate at Marnie's. It's really great I get the chance to talk to you tonight about my favourite and what are some really interesting parts of the law. They're also important to healthcare practices, as we'll see. Tonight, I'm going to run through some key considerations about brand protection, privacy, and clinical trials. Once I get the mouse. Oh, there we go. Great. All right. So let's talk about what is your practice's brand. Well, it's your staff. It's the goodwill. It's the stuff they know. It's what they do for your patients. It's how they make your patients feel. It's your premises. Is it comfortable? Does it look cool? And then it's the collision of all that in a pretty picture and memorable name, an immediate link to your offering and values. So why protect your brand? Well, it's an asset. Your practice will become successful. Your brand will be worth something. Spending on advertising and quality service delivery is brand value. You're going to commercialize that. When selling your practice, a smart buyer is going to want a good brand that's properly protected. And you don't want to be confused with not so good competition. So how do you protect your brand? There's a few ways you can go about that. But the biggest thing is to select a brand you can protect. It should be different to other brands, so conduct searches before selecting a brand. It shouldn't be descriptive, so Bob's Brain Doctors is out, and it should be distinctive. Keep an eye on your competitors, especially in your geographical markets. Take action quickly to stop infringement or competitors trying to trade off your brand. So, registration. If you can, you want to register your brand as a trademark. This avoids you having to establish a reputation in the market to sue for infringement of your trademark, which can be difficult. All you need to show is that a competitor is using a similar brand to the one you have registered without your permission, and you have an action against them. You can stop the infringement. What about if you can't register it? You've already got a brand that you've been using for a little while, and it might not be suitable for registration. Well, you may have common law rights. Lots of reputation is good, but you've got to show that reputation. You may have actions of passing off, misleading and deceptive conduct and other remedies. So I'm going to move on to privacy now. Should you care about privacy? Yes. Why? Because the Privacy Act and Australian privacy principles apply to you. You deal with personal information daily. And our society is becoming increasingly concerned that you take care of it. The obligations in respect of health information, so your patient's files, are stricter than other types of health information and personal information. Patients have the ethical and legal right to make informed decisions about their health and who has access to that health information and what can be done with it. As Chris will explain later on tonight, The healthcare industry needs to do better in respect of privacy. We expect the regulator to increase its scrutiny of and enforcement action against healthcare practices in the coming years. As telehealth and other forms of electronic communication become more widely used in the healthcare post-COVID-19, there will be a significant focus on privacy protection and the practitioner's responsibility to care for privacy. There's penalties. Last year, the government flagged significantly increasing the maximum penalty for breaching privacy laws, which is currently 2.1 million, and providing the regulator with new powers to easily issue infringement notices for failure to assist resolve minor breaches. So the maximum fines that could be issued under an infringement notice are 63,000 for companies and 12,600 for individuals. My Health Records, the My Health Records system allows access to sensitive personal information about your patients. You must comply with the My Health Records rules and legislation, or you may be restricted from using My Health Records. My Health Records rules sets out security requirements. Example, you must document and implement internal practices and procedures used to protect the personal information. There's also penalties under this instrument. You'll see that they're pretty significant for breaching the My Health Record rules. A breach of these rules also interferences with privacy for the purposes of the Privacy Act, and so you could get stung under the Privacy Act as well. The mandatory data breach scheme is something you all need to be aware of. If there is an unauthorised access or loss of your patient's data and it's an eligible data breach, you may have to report it to the regulator and your patient. An eligible data breach is an actual or potential unauthorised access, disclosure, or loss of personal information by your practice, resulting in what a reasonable person would consider is serious harm to your patients. And what's serious harm? It's broad. It could be financial, psychological, emotional, economic, or reputational damage. If you've got reasonable grounds of suspicion that a data breach has occurred, you must investigate and confirm within 30 days whether there was a data breach and if it was an eligible data breach. If it is, you've got to notify the Australian Information Commissioner. You could be subject to fines and affected patients, brand damage. So you should also consider whether you must notify the data breaches under the My Health Record rules to the Australian Digital Health Agency. So it's no small task. What should you do to help comply with your privacy obligations? Well, you want to pay close attention to Chris as he speaks later. That's super important. He'll give you some really practical and specific guidance and resources. But broadly, the key really is informed consent and insurance, but I'll let Chris speak to that. Informed consent permits collection, use and disclosure of the patient's personal information. Many medico-legal proceedings result from a failure to obtain consent. Some other steps: know how to collect and use personal information properly, understand that patients own their health information, know what to do in the event of a data breach, only collect information necessary for one or more of your functions, no direct marketing, that's out. When giving out health information, make sure it's relevant for the proposed purpose and protect personal information from misuse, interference, and loss, from unauthorised access, modification, or disclosure. So get some good virus protection software, and you want two-factor authentication as well. And that just means your staff members are getting a text message as well as having to put in a password to the computer. Okay, so let's move on to clinical trials now. Australia has some of the best research capabilities in early phase clinical development in the world, as I'm sure you're aware. It's 28% cheaper in the US before tax incentives and 60% cheaper after tax incentives than the United States. That may in part explain why every year over 1,000 new clinical trials are commenced in Australia by biotech, medical device and pharmaceutical companies. There are several clinical trials in Australia for a COVID vaccine at the moment, which is super exciting, including one with 10,000 participants, 2/3 of which are Australian. That's super cool. So look, I've listed some important regulatory instruments there that you can read in your own time. If you're going to be involved in a clinical trial, you need to be across them. So I've also set out some key obligations that you want to think about. As a principal investigator of a clinical trial, you want to protect the rights and safety of your trial participants. You need to supervise your research team. You need to conduct the clinical trial as per the clinical trial protocol. except where necessary to eliminate immediate hazards or with sponsor institutional ethics approval. You need to be familiar with and comply with the principles of good clinical practice. You need to record everything. This is really important. You need to record delivery details to the trial site, use by each subject, record dates, quantities, batch numbers, expiration dates, everything. Put it down in writing. Be familiar with and comply with the regulations that apply to you in a clinical trial. If it's an investigator-initiated trial as opposed to a sponsor-initiated trial, you're going to take on the responsibilities of trial sponsor. You'll be responsible for both the management and conduct of the trial. Any departures of the clinical trial protocol that may affect patient safety or the reliability of data need to be reported. And that reporting needs to happen to the trial sponsor, the Human Research Ethics Committee, and approving authority. You also need to check your insurance with Chris. That's super important. You need to be covered. Look, I've listed some additional responsibilities there as well. There's heaps. I've tried to pick out the most crucial, and I think one of the most crucial is getting informed consent. You need your Institutional Ethics Committee's approval of the written consent form, revise it and resubmit it when new information is received. You or your trial staff cannot coerce or unduly influence a subject to continue in a trial. Give the subject or its legally acceptable representative ample time to decide whether to participate. And the written informed consent must be signed and personally dated by the subject or its legally acceptable representative and by the person who conducted the informed consent discussion. So you want to be considering what you need to do if the patient or the trial participant doesn't have good English speaking skills. You might need to get a witness. Some other key responsibilities of yours: the patient's care and treatment, obviously. So think about adverse events, clinically significant laboratory values, and when you need to report and take action. You need to have adequate resources, so time to undertake the study, properly qualified staff, etc. Ensure all your staff are adequately informed about the study protocol, and any change to the case report form should be dated, initialed, explained, and should not obscure the original entry. So consider correction protocols that the study will no doubt have in place. So that's all from me tonight. It's been a real pleasure presenting to you. I hope you find the rest of the session informative.
Thanks for that, Rhys. Our next speaker is Rhys Mariani. Rhys is Director at Medical and General Risk Solutions and specialises in helping medical practices manage their business risks through effective risk management strategies and insurance. I'll now hand over to you, Rhys.
Thanks, Tori, and thanks, Rhys. So tonight I wanted to give you some really practical tools and things that you need to do to be aware of your obligations under the Privacy Act, where to get some information that you can start to build what's called a privacy framework, and just some common things that I see go wrong day to day in medical practices. I spend, or at least I used to spend pre-COVID, probably half my week actually inside medical practices helping them deal with the insurance issues, but also things like the Privacy Act and how to get compliant, what happens when they've had what Rhys referred to before as an eligible data breach. So let's start. I'm not going to talk much about insurance, but if I do, there is a general warning on this slide that talks about it's general information, it's not personal information. Please go and seek your own advice. So let's talk about the things we're going to talk about tonight: privacy compliance. You'll hear me talk about a privacy framework, and I'll explain what that is. I'll talk about the notifiable data breaches. When is a data breach a notifiable breach versus not a notifiable breach? Rhys has talked about the fines. So when are you actually likely to cop a privacy fine? Are you going to get a fine, or what else is going to happen? The practical importance of, in terms of contracts. So when you come to sign contracts with IT providers, employees, etc., what you should look for in those contracts. And just a note that much of the information that's in this slide, I've taken snapshots from the Privacy Commissioner, or the OAIC, which is the Office of the Australian Information Commissioner. They've got some great resources there. So where I've used their information, I've put a link that you can go straight to that exact slide. So let's talk about a privacy framework. The Privacy Act basically says every business that's subject to the Privacy Act, which is basically every single health business, needs to have what's called a privacy framework. And you go, well, what does that mean? And it talks about embedding, establishing, evaluating, enhancing your privacy framework. If you clicked on that link, up would pop a whole heap of information, and it guides you through 30 or 40 things that practically you need to do to ensure that you can say, I've got a privacy framework and I broadly meet the requirements of the Privacy Act. I've got a couple of slides coming up on that. Not only is there the framework, there's actually pages specific to health. So you can go straight to a guidance paper that the Privacy Commission has written specific to medical practices. This applies equally to things like gyms, because gyms collect health information. So when you click on that privacy framework link, what actually happens is up pops another link, and you'll see in this slide, there's towards the bottom of it, it says the privacy management template is now available to download. When you click on that template, up will pop a number of pages. I've just copied the first page, and it talks about what you need to do in step one. So this is the idea of when you're starting a business or you're starting something new. An example of something new is the COVID app. We're going to talk about that in a minute, and how the government did a what's called a privacy impact assessment. That equally would apply to you if you start telehealth. So what happens if you start telehealth? You should be doing an impact assessment and deciding, how am I going to provide telehealth services? Am I going to do it through Zoom, which we're doing tonight, or am I going to do it through some other system or a specific health program that's been designed to specifically keep the data in Australia and is more secure than, say, Zoom may be, for example. So you're meant to make an assessment of what's the right thing for my patients and myself. What are the privacy implications? How do I best make sure that I've considered the needs, the privacy needs of my client base? So each of these steps talks about a whole range of things you've got to do. One of the most common things in this is training your staff. I go into clinics all the time, and we do a 1 hour training presentation on privacy. And invariably the staff will come up to me and say, Chris, I've been here for 3, 5, 10, 20 years. I've never done a privacy training session. In all my time here, I didn't know about any of these things. I was never told. I don't even remember signing a confidentiality clause in my employment contract. That's a very common scenario that I have. And so if you think about yourself either working in your own practice or working in another practice, have you actually ever done a training session with your staff? If you look at step 2, for example, step 2 talks a lot about, later on in that slide, about integrating privacy into staff training, induction processes, developing a privacy policy. You've got to do all these things and make your staff aware of them, because invariably they're the ones that are going to take quite often the initial phone call or the initial, they're going to identify the potential privacy breach and have to raise it with you. What I do for my clients is create a spreadsheet. And this is, again, just steps 1 and 2 of that privacy framework. And it just puts those things into a spreadsheet. We record when we've done them, when we've finished them, who's the person who gets all the responsibility to deal with these things. And then we have follow-up dates and we review them, as these. So, for example, privacy training that should be done annually, we'll have an annual reminder to run another privacy session the following year. I've also got things like a checklist. If you want to send me an email, I can send you the full checklist. This is the first page. It's about 2 or 3 pages long. Just talks about the things that you should have in a practical sense to say that you have a compliant privacy framework. So have you done the training? Do you have a privacy policy? Do you have a breach plan? Do staff sign contracts that talk about confidentiality, that talk about the use of IT or social media in employment contracts? Do you have a consent process for your patients? Rhys talked about consent in clinical trials. When you're collecting health information, you need consent from patients to collect that information. It's not like any other bit of personal information. You go into a bank, they don't need to ask you for consent to collect your name and address. You go into a medical practice, the practice needs to request your consent to collect your health information. It's one of the unique things about health information. It's counted as sensitive information, so it has a higher standard of care. The first thing that I do when a new client comes to me is I actually Google them. So quite often a doctor may send me an email and say, Chris, I've been given your name can we have a chat? And I'll Google them, and up will pop if they've got a website. Invariably, 99 times out of 100, especially when they're not a GP, GPs tend to be a little bit better because they go through accreditation, but you go to their website, they have no privacy policy. Or if they do have a privacy policy, it's 10, 20 years old. It still refers to, for the example, the words national privacy principles. You'll see this one up on this website says the Australian privacy principles, which is correct. The national rules were removed and the Australian privacy principles started in March 2014. So there's an easy way to see if a practice has even updated their privacy policy in the last 5 or 6 years. This is actually one of my clients who gives me permission to share this screen. This is a fully compliant privacy policy. It goes on for a number of pages, but it talks about how they collect and use and store and secure, whether they send information overseas. This is the standard that the Privacy Commissioner expects every health business to have. I encourage you to Google your own website if you've got one, or all of your friends and colleagues, and see actually if they've got anything that's remotely similar to what something like this should look like. And again, I have templates and provide a lot of help to clients to try and get them up to speed with privacy. I spoke to someone this week, they developed a website. I clicked on the little privacy icon at the bottom of the footer, and up popped a whole heap of words in Latin. Their website guy had rightly put space for a privacy policy, but the practice had actually never completed the privacy policy. The words were still sitting in just random Latin words that no one had ever looked at. If you've had a breach, what do you think the first thing is that the Privacy Commissioner does if they come looking to investigate you? They do exactly what I do, which is Google you, find if you've got a website. If they see that you don't have a privacy policy and it's not correct, they're already making an assumption of you that you're a bad practice. The time you're absolutely likely to get the privacy fines that Rhys talked about is where the Commissioner has said, you're a bad business, we're going to make an example out of you to encourage others into good privacy behaviour. So the biggest risk management tip that I can give you tonight is don't be in the bad business bucket, get compliant with the Privacy Act. If something goes wrong and you can put your hand on your heart to say we've taken reasonable steps to protect patient privacy, then you are far more likely to not receive any fine and to not receive any penalties and other actions. So I spoke before about a privacy impact assessment. Again, there's a page on the Commissioner's website that talks about how to undertake a privacy impact assessment. If you're really keen, you can actually look at what the government wrote about the COVID Safe Act, about how they've made sure that the data that they've collected from us as Australian citizens who have downloaded the COVID Safe App is protected. I actually read this thing, like probably many lawyers have, and I decided to download the COVID Safety App. I didn't think it was an issue. We give up far more personal information to Google and Facebook and all the other social media platforms every day than what's in the COVID Safe App. But the government rightly produced a privacy impact assessment. So when you've decided to do telehealth with patients, have you done a privacy impact assessment on why you use Zoom or Microsoft Teams or Skype versus some of the health systems that are available? Notifiable data breaches. This is one of the things that if you said to a practice manager or the owners of a business, what's a notifiable data breach, very few people could actually tell you. You need to understand this as a medical practitioner and especially as a business owner. And again, there's a page on the Commissioner's website. And what it really says is the notifiable data breaches scheme, when something becomes an eligible data breach, these three things must happen. So the first thing is there must be unauthorised access to or disclosure of personal information or circumstances where that disclosure or access is likely. The event is likely to result in serious harm to any of the individuals. And that's not defined in the legislation as to what is serious harm, but the Commissioner has come out and said an example of serious harm would be the loss of medical records. So pretty much when something happens in the medical space, it will be serious harm. And the third thing is whether if you've been unable to prevent the risk of serious harm. So an example of that may be, you may have triggered the first two things where, say, you've sent a fax to the wrong fax number and it's got really sensitive patient information in it. It's going to result in serious harm, but it's gone to another clinic or a hospital and they've called you up and said, look, we've obviously accidentally received this. We're going to shred it or destroy it. In that case, you've been able to remediate the risk and there is no serious harm, so it's not a notifiable data breach. If, however, that went to the local fish and chip shop and they decided to post it up on the front door for a bit of fun, then you would trigger the notifiable data breaches scheme. One of the requirements in the Act is if it's not clear, you need to conduct an assessment, and you only have so long to be able to conduct an assessment to determine whether something's a notifiable data breach. If it is notifiable, what it essentially means is you've got to dob yourself into every impacted individual and also the Privacy Commissioner. So you're writing to them saying, I've had a data breach, this is what's gone wrong, this is what I've done to deal with it, this is what I've done to make sure it doesn't happen again, and you hope to be able to craft a response so that you don't end up with a fine or some sort of regulatory action. You can actually go onto the Commissioner's website again and download their quarterly reports. For all of those things that have been notified, the Commissioner produces a quarterly report, and they even divide it up by the types of things that go wrong by different industries. So you'll see in this for the January to July period, so this is a 6-month one, 537 notifications, 64% of those events were relating to malicious or criminal attacks, so the cyber hacker, 32% human error, so an employee just faxing the health results to the wrong person, 4% a systematic fault in some sort of system. Rhys before spoke about health needing to improve. It's absolutely the most common reporter of data breaches. But in fairness to medical practices and doctors, there's a couple of reasons for that. The first one is no other business becomes subject to the Privacy Act until their revenue reaches $3 million a year. Health businesses become responsible at $1 of revenue. So we're not comparing apples, with apples in that case, because lots of the small businesses that had data breaches have no obligations to report. The second part is that doctors generally are pretty aware of their obligations, and they're probably far more likely to report breaches than other industries. So whilst health has continuously topped the tables in terms of the most number of notifiable breaches, I think there's a pretty reasonable understanding of why that's the case. And again, there's a whole lot of data that the Commissioner produces about whether it was a phishing attack or whether it was malware or some sort of brute force attack in systems. And it's all divided up by whether it's a healthcare business, etc. If I was a practice owner, I'd absolutely be looking at these things and saying, what are other medical practices falling for? And I don't want to fall for those same, things as the rest of the practices. So is it a notifiable data breach? So let's make a couple of assumptions, and this is actually a real life case that I only finalised probably 3 or 4 weeks ago. GP clinic opens up an email. It happened to be the practice owner, so quite often it's not the staff. Generally, it tends to be the doctors or the owners of the practice tend to do the most stupid things. So the practice owner opened up an email, clicked on a dodgy link. Their system immediately downloaded what's called the RYUK virus, quite a nasty virus, and it completely encrypted everything that was sitting on their server. They were a server-based system. They also had a remote backup overnight through the NBN to a cloud-based system. So what actually happened? So as soon as that cyber attack happened to the RYUK virus, they called up their IT guy. He immediately managed to remove the virus. They had to wipe all their systems, and they loaded yesterday's backup. It meant that thing happened at about 2 o'clock in the afternoon. They lost all their patient records though up till 2 o'clock. So they had to recall back all the patients, recreate the medical records, make sure that there was nothing missing. Rhys before spoke about the My Health Record system. One of the obligations that we had was to make sure that the My Health Record system wasn't compromised. So we had to do a big investigation. Lawyers, IT experts all got involved to make sure was it a notifiable data breach? Was the information actually accessed by the hackers, or was it just encrypted? Was anything lost? How did that all, what happened in that case? Now, in the end of that thing, the insurance company paid out about $80,000 to $90,000. A lot of it was lawyers and IT fees. There was about $50,000 in lawyers' fees. There was a couple of days where the practice had limited systems because of the rebuild, so they had some lost revenue which was insured, and we also had to pay some extra staff overtime and other costs. So all of that picked up by what's called a cyber insurance policy. What the lawyers decided after doing all the assessment was that there was no patient data was accessed at all. It was just encrypted. All the data that was lost was later recovered through either the backup or the manual patient recalling and the recreation of the records. Therefore, it was not a notifiable data breach. So whilst the patients all knew something happened because they were called back in for an extra consult, there was no obligation to inform the Privacy Commissioner because they'd done their breach investigation, they remediated the risk, and therefore it wasn't a notifiable data breach. Let's talk about something that can happen quite comfortably or quite often. So an employee goes home tonight, mentions a patient X that came into the clinic today, had Y symptoms, no specific name was given, no specific information, but say we're in a small rural town or somewhere where that series of information is fairly, wouldn't apply to too many people. So this is another real case that I was involved with last year. Family member of the employee puts 2 and 2 together, identifies the patient. They go to basically a party, and the patient becomes aware their health information was compromised. It was a sensitive condition they had. The patient made a complaint directly to the Privacy Commissioner, who investigated. The practice was then exposed to the privacy fine, the patient suing, all the regulatory action. The employee was exposed to disciplinary action. So the patient basically, as one of their requirements, said we'd like the employee fired. The practice had to go through their employment conditions with the employee and issue a formal warning letter about privacy and their obligations, etc. So what happened at the end? Well, the big lesson out of that is de-identified personal information can still be re-identified. The Privacy Act talks about that. So just because you've not said the patient's name or some other personal details doesn't mean that it's not re-identifiable. In this case, it was actually a notifiable data breach. And what actually happened in the end was a small commercial settlement to the patient for them to cease any further civil action, and the Privacy Commissioner agreed that that was a reasonable outcome and then didn't enforce any of their own penalties. So when are you likely to cop a fine? The short answer is when you can prove you've taken no reasonable steps to protect patient privacy. If you don't have a privacy framework, if you don't have good IT systems and security, if you can't show reasonable steps to protect privacy. Those clients before that I talked about had very good systems. Things still go wrong, and the Privacy Commissioner looks at it and says you're a good practice and no fine. Note that the fine is separate to a civil claim. So in a civil claim, that's where the patient's effectively going to the courts or a lawyer and saying, I demand X thousand dollars or X $1 million for a breach of my privacy. You can still have that civil claim, and you can still have the commissioner still issue or seek a fine against you. Most medical indemnity policies will only cover the civil claim, not the privacy fine. Some policies now are extended to cover, but you need to check your own insurance cover. And those that do, their supplement may be something like $250,000 for the fine, which may or may not be enough. So generally, most medical practices should have what's called a cyber privacy insurance policy. So as I said before, the role of the Privacy Commissioner is to encourage businesses to take reasonable steps. So really their job, they've come out publicly and said, we're going to make an example out of the bad businesses. So don't be a bad business. In a number of the cases I've had, what I've seen is, again, the practice having to make a small civil payout to the patient rather than the Privacy Commissioner issuing a physical fine to the practice. What you don't want, though, is the headline like Health Engine, which were, are probably going to, you'd imagine will face some regulatory action where they were basically selling patient data to third parties for financial gain. You don't want your practice name in the headline for doing those sort of things. Contracts and privacy. I spend a lot of my time each week looking at IT agreements. They are normally terrible. They are drafted by people like Anthony and Rhys when they're working for the IT companies as lawyers. You as the medical practice, unsurprisingly, those contracts are never in your favour. You need to go to a good lawyer like Anthony and Rhys and have those terms looked at and very often changed. The biggest issue that I have quite often is if you're dealing with a small IT firm, if their revenue's under $2 million, they're not subject to the Privacy Act. So they're holding the keys to the cupboard, your patient data, they're responsible for it, they're trying to secure it, yet they have no legal obligations under the Privacy Act. So the contract you have with them needs to stay. They're required to abide by the same rules that you are, by the Privacy Act. They've got to help you with things like a breach assessment. So if something goes wrong, like with the GP client earlier, the first people you need to call is your IT guy asking for help to deal with the breach assessment and the restoration of your systems. If there's no requirement in the contract to deal with that, you can have a lot of issues, and the IT guys will start to think, geez, maybe we caused this, maybe we're not going to say anything, we'll start to hide things, and you've got a lot of issues. And IT firms' lawyers that draft the contract, they will try and contract out of all liability, even if they're negligent. So their contract will say either we deny all liability, you sign this and you can't sue us, or the most we can be sued for is the value of the services we've provided to you. That's not fair. That's not what you do to patients. No doctor gets a patient to sign a contract that says you won't sue me if I'm medically negligent. Most IT firms, in my experience, have little or no idea about the Privacy Act. Again, when you, if you're on your computer right now, go to the website of your IT guys and see if they have a privacy policy down in the footer of their website, and whether it's compliant with the Privacy Act. Many don't. So what do you need to do in IT contracts? You need to get the clauses right, get the things that need to be inserted in there inserted, get the what's called the indemnities or the limitations removed where possible. You need to do an IT privacy audit. So you need to ask about things. If we're hacked, how will the hackers get in? How quickly do we get our data back? I've got a list of questions up on my website in an article I wrote about. There's about 8 or 10 standard questions that I have IT guys answer. And it gives you a good sense about whether they're compliant with the Privacy Act, how quickly you'd be back up in business if there was a cyber breach. And also things like benchmarking against my fellow peers. So if your IT guy looks after 1,000 other practices, where do you sit relative to those IT guys? So in short, use an IT provider who specialises in medical and will assist you to get compliant, is willing to enter into a fair contract which aligns to your interests. So you and them should be in the same bed, looking after the privacy of your patients. From an employee perspective, what you need to do. Employees need to sign an employment contract which includes the obligations of privacy, confidentiality, ownership of intellectual property. Privacy and confidentiality are two similar conditions, but the Privacy Act relates to the personal information of people, whereas confidentiality can be broader and include things like business secrets and policies and procedures and other documents that you have, how you run your business. You need to make sure employees, when they leave, don't go and take that information and then set up across the road or provide that to their new employer. You must have policies and procedures and show that the employees are aware of them. So there's no point yelling at an employee when they commit a Privacy Act breach if you've not trained them. That's your fault. You need to train your employees on what their obligations are and how to avoid doing, breaching the Privacy Act. So how's the employee to know they can't go home and discuss what they believe is de-identified personal information? You need to make sure that you've made it clear that they can't go and do those things, because that information can be re-identified. One of my final slides is a lot of those links all in the one spot. If you've got a practice manager, the best thing that I can encourage you to do is, once you've got access to these slides, is send them that and say, go away and have a read of all this stuff. Whoever is your privacy officer in your business, which is normally the practice manager, should be a guru in this stuff. They should know how to develop an APP privacy policy, how to have a breach response plan, what a privacy impact assessment is. They should be doing an IT review with your IT guys each year. So a lot of this stuff we'll talk about that. I hope that was helpful. There's a whole heap of extra risk and insurance information again at my website. You can have a read in the news section. There's far more stuff about risk management than there is about insurance. So hopefully it's a more interesting read. And I'll hand over to the next speaker.
Thank you so much for that, Chris. Please welcome Damien Greer. Damien is an accredited family law specialist, a mediator and an arbitrator with extensive knowledge and expertise in all areas of family law. Damien, I'm just on the first slide.
Point slides.
Hello, Damien, can you hear us?
Yes.
Great, so I'm just on the first slide.
Thank you.
That's okay.
Good evening, everyone. You can now see my first slide, which will give you an indication, or the second slide will give you an indication of how much I enjoy PowerPoints. I assure you, you haven't got 666 to look forward to. I'm talking to you this evening in relation to the family law aspects arising from where we are financially and socially, and how to protect ourselves. Anthony is going to be talking to you after me, and he's going to be talking to you about the structuring that you should be looking at or should have in place to look after the wealth that you're generating and your family members. And he'll be talking to you about wills and powers of attorney, and generally in relation to estate management. And I've seen Anthony's presentation before, and I've seen his slide presentation. It's a very good and one to be taken in carefully. But the thing that, from our perspective as family lawyers, when we look at the structuring that we see, and it's becoming more apparent as time goes by, that the structuring is devised or thought of when looking after the family wealth from commercial predators, if you would, falling to litigation and other disputes where people can try and attack your assets in different fashions. But in the modern Australia we live in now, we have marriages, we have de facto relationships, and we have same-sex relationships. And whilst they're all gifts in their own particular way, they're also a bit of a Trojan horse, because when you have the typical structure set up that's devised to protect you as far as the corporate vicissitudes of life are concerned, it doesn't protect you if you have a family dispute. And that could be a partner, it could be the partner of one of your children, and you never really think about it when these people are coming into your lives. Certainly you make provisions for your children and your wills. You set up, and Anthony will talk to you about testamentary trusts in the way that you protect assets and manage them in particular fashions. But people don't think about it from the perspective of how do I do it from a family law perspective. Now, certainly we work with Anthony and also accountants in helping structure some of these to avoid some of the issues. And the course that we recommend is that people consider doing a financial agreement. And that is really a contract between the interested parties that effectively ousts the jurisdiction of a court under the Family Law Act and allows parties to enter into arrangements that are best suited to their own affairs and would not necessarily be an outcome that a court would or a judge would necessarily agree to or make orders in relation to. So that I'll go into financial agreements a bit more in a minute, but the issue in relation to family law is how does it work? What can a court do? Well, as I said, courts can make distributions of or affect people's assets or families' assets from the perspective of maintenance, distribution of any assets are owned by people, and that can include companies and trusts. And that's been very clear. It's been to the High Court, and the High Court has confirmed that the family court or a family court judge can make orders that will affect companies and trusts if the court is of the view that that's an asset of one of the parties or of the parties or is in the control of the parties. So that when you're now structuring in future, when you're talking to your accountants and you're talking to your lawyers, you must be talking to them about how you can control your assets into the future and what protections you can have, not only in relation to your own assets, but also the next generation, because if you have interlinked investments with the next generation down, that can cause you problems as well. So the court looks, in very brief form, it looks at in trying to work out how distributions should be made. They look at the financial contributions that have been made as to what you've got now, what you've brought into the relationship, and from any aspect. And that's always pretty easy for us to look at because it's looking at numbers, but where people get caught out on the contribution side is that they don't particularly take into account the softer side, if you would, and that's running the household, raising the children, and looking after each other generally. We try to come up with a percentage division on that basis in a lot of cases, and then the court's required to look at the present and future financial circumstances. Is it looking at income and capacity, etc., going into the future? So a family court judge has a very, very wide discretion as to what they think is an appropriate distribution. So what we say is that you should think about doing a financial agreement so that you're not putting your financial affairs into the hands of a stranger. Now, you can have an agreement going into a relationship, you can have an agreement during the course of your relationship, and you can have an agreement subsequent to a divorce. And these agreements are very particular because you're asked in the court's jurisdiction, and you have to be very careful that they're done properly and in accordance with the legislation. We always recommend that you engage with an accredited family law specialist, and you can find links with the relevant state law societies that will have a list of accredited family law specialists who will know how to deal with these matters. They have to be done, as I said, in a particular form, and the lawyer who advises each of the parties has to sign off to say that they've properly dealt with or properly advised people as to advantages and disadvantages of the agreements. So we're of the view that they are a good thing to look at. There have been various cases over the years testing them, and as the years go by, we tend to find that the courts are more supportive of agreements properly done. And in one case, in which I was involved in, the judge pointed out that an agreement properly done for a party who complains about it, as long as they've had the proper advice, it doesn't matter how bad the agreement is in most cases, they're stuck with it. Now, what we're going to look at the next slide is what will this session cover. And it's going to look at reviewing existing arrangements and what are factors to consider. Can existing arrangements be changed because of the COVID effect, and is this an opportunity? It's interesting when you have a look at the current pandemic that we have. It's a number of generations since we've had one like that, and the last one being the Spanish flu. And there's a link that I'll have on my website tomorrow that will take you to an article in the MIT news outlet that refers to a study that some of their researchers have done. And in MIT news, they have said that their study, which is co-authored by one of their economists, shows that taking care of public health first is precisely what generates a stronger economic rebound later. And so I'll let you have a look at that. But the reason I'm pointing to that is that the Family Law Act came into existence in 1976. Since then, we've had the 1987 stock market crash. We've had the recession that we had to have in 1991. We've had the tech wreck, or the Twin Towers episode in about 2000, 2001, and then we've had the GFC in 2008/9. Now, the reasons I refer to all of those is to give you an indication that there's a body of jurisprudence that's grown up in the period of time that the family court has been in existence that has dealt with economic vicissitudes over about 4 decades, or a bit more, coming on to 5. So the case law that we as lawyers deal with does take into account the current circumstances. I know that a lot will say that this is very much a new experience, but in a lot of ways the case law that's come out still covers what we're experiencing, and there are a lot of views that the steps that have been taken as far as the economy is concerned is that it's going to lead to a stronger economy, but there are going to be a lot of people who are going to be adversely affected during that time. So if you've got a financial agreement in place, where does that leave you? Because you've drawn your financial agreement up on the basis of what you thought the future was going to hold for you. If a financial agreement has been drawn correctly, then it is going to be flexible enough to cover the issues that you have. But if you do have to go back to have an agreement adjusted, it can be done, and it's done by way of what we call a terminating agreement, which is which has to be dealt with in a particular form, and you do have to have lawyers involved. And then you can enter into a new agreement if you have to. And it's a bit like Anthony would tell you as far as your will's concerned. When you set up your structure as far as your estate's concerned, you should be revisiting it when important financial events occur or important life events occur. Similarly, with financial agreements, you should have an arrangement in place where you can come back and reconsider it and adjust it as necessary, and it has to be done by agreement. But if it's not done by agreement, then an application to the court is necessary. And the factors that the courts are going to have to look at are varied, but if it's not done by agreement, it can be a difficult course to run. So it is much, much better to try to negotiate a resolution if it is possible. If not, of course, there's mediation as an approach that can be undertaken. But if an agreement is drawn properly, as I said, it will have the necessary adjustments that will allow for the parties to deal with matters such as we're experiencing at the moment. But by and large, the issues that we do see is that a lot of parties will be bound by the agreement, but the financial circumstances will adjust in a fashion that will be reflected in the agreement. The other agreement that goes with these, of course, is in relation to a binding child support agreement. In the family law world, child support is dealt with in a different regime through the Child Support Agency. They undertake assessments if parties can't agree as to what payments should be made as far as support of children are concerned. There's no obligation to have a child support assessment. It's only where people can't agree with each other. Parties can agree in relation to arrangements by undertaking what's referred to as a binding child support agreement, and this might be something that you might wish to consider if you want to, and there's a breakdown of the relationship, and you want to regulate the arrangements that you have as far as your children are concerned going into the future. That can, the advantage in having a binding child support agreement in place is that it is fixed. It can only be set aside by order of a court or by agreement between the parties in a formal sense. But it then means that parties can then regulate their own financial affairs into the future without concern about having to expose themselves to inquiry by the former partner. They can be quite extensive as far as the things that can be covered in a binding child support agreement. It can be, it can talk about how much is paid on a weekly, monthly or annual basis with an uplift if necessary. It can be one that talks about school fees, health insurance and the like. But the important thing in relation to a binding child support agreement is that, and this is where it comes back to where we are now as far as current economic circumstances are concerned is that if it's drawn properly, it must have some triggers put into it. We do speak to our clients quite a lot about the triggers that should be contained within a binding child support agreement so that you don't find yourself stuck in a situation where your income has dramatically dropped and you find yourself committed to paying monies that you no longer have. So if the agreement is drawn properly, it will have a trigger point such as a decrease in income to a particular level. For instance, perhaps you might think of $150,000 per annum, or you might think of some other figure. We say that if your income comes down to that, or your income and capacity is terminated due to health issues and that sort of thing.
Sorry to interrupt,
Yes.
Damien. We've got another 5 minutes of your presentation to go.
Thank you. You have the opportunity to have those adjusted. Now, in general terms, are there any opportunities at the moment? The experience that we have with our clients is that some are very enthusiastic about current circumstances if they're consulting with us about resolving their financial affairs. That is, that they see that there's going to be a negative effect upon their business arrangements, and they are keen to take advantage of that. But others, and this seems to be in the main at the moment on the advice that we're getting, is that they're being very cautious about entering into or finalising the arrangements because there's uncertainty in relation to the value of businesses, for instance, property values and the like. At present, when we're dealing with accountants, we're not seeing too much in the way of change coming through from them as far as the capitalisation rates that they might be applying to the value of businesses. But it's still, I think, early days as far as that's concerned. And it also depends upon the sort of industry that you're in. With many medical practitioners, however, because you are generating from your own efforts, you'll find that the valuation of your business as such, depending upon how it's structured, will not really be affected to any great degree, other than if you've been working in the world of elective procedures and you've been put out for the last 3 months, but that no doubt in the next 12 to 18 months will recover. And that's the sort of thing that will be said to people in relation to their query about should they be pressing for a settlement now, or should they be pressing for a settlement in the future. So that from our experience as family lawyers, looking at what's happened over the last 4 decades, we've seen that there's been a reasonable increase or return to wealth over that period of time. I know we've had 29 years of without recession, but the experience is, and you will find that the approach taken by the courts, if there is a dispute, is that in the longer term things will return to a reasonable position as far as financial circumstances are concerned. But certainly it is an opportunity for you to revisit, for instance, any agreements that you've got, or you should consider revisiting them to make sure that they cover your circumstances at the moment. Thank you.
Thank you for that, Damien. Our last presenter this evening, Anthony Harrison. Anthony is a partner of Marnie's with over 20 years of experience leading a team that specialises in commercial and corporate law, commercial property and estate planning and succession. Over to you, Anthony.
Apologies, everyone. Just had a bit of a meltdown with the computer stuff. So thank you very much for the introduction. Like I said, thank you guys for hanging around today. We're going to talk today about estate planning, and it's the graveyard shift. So I'm the last one, so it makes sense that we talk about estate planning. As I'm a lawyer, the first thing I'm going to do is re-emphasize the disclaimer. Everything that we do say here is general. If you want specific advice, you need to go get specific advice tailored to your needs. Now, that applies for both insurance, it applies for estate planning, it applies for branding, and it applies for family law. So what are we going to talk about today? Now, I've bracketed estate planning with asset protection. And as Damien pointed out, we really need to sit there and actually talk about the two. And what I'll do is I'll explain to you the interaction of one of the risks, which is spousal claims when you get into the asset protection. But the first part is to understand the importance of actually looking at your estate planning in light of COVID. We're going to go through why we need to look at this now and why it's at the forefront of a lot of people's mind. The second point is, what is it? What is estate planning? What is it asset protection? I'll explain to you about how for some people it could be as simple as a will and enduring power of attorney, and for some other people with trusts and companies, it could be a much more complicated affair. When you talk about estate planning, well, what does and does not form part of your estate is a critical question. So we talk about trust assets, we talk about company assets, and we're going to have to talk about the idea of joint tenancy and tenancy in common. This has a huge impact in relation to your estate planning. What is a testamentary trust? A great question came up on the Q&A during one of the talks that I had to answer about should I be using a discretionary trust or a testamentary trust? I'll explain to you why a discretionary trust can be used, but why a testamentary trust is usually better. Also, what happens to assets that fall outside the estate? If you do have a trust or a company asset, where does it happen? Does it deal by your will? How does it? Who controls it? I'll explain that. And what other documents are needed? You know, we talked before, Damien mentioned before about an enduring power of attorney. That's one. What about trust reviews, deed of variations, things called statement of wishes, statement of directions? There's a lot of other documents that you need to sit there and look at, and they may or may not be relevant to you. And finally, and really importantly, how do you do this safely? One of the things that everyone's really concerned about, that's great. I want to do my estate planning, but I don't want to leave the house. I'm 80 years of age and I have got respiratory conditions. I do not want to leave the house. How can I do that in a safe environment? So what we'll do is first of all talk about in light of COVID. Well, I hate to be blunt, but it actually leads to incapacity and death. It brings that to the forefront. You've got to think about your mortality and understand that you need to deal with what happens if you die or you're incapacitated. In which case, who do you want making decisions about your finances if you're on a ventilator or you die? Also, who do you want decisions made of your loved ones? And that extends beyond just your partner, not your wife, your husband, or your partner or de facto. It's also your parents, your grandparents. Who do you want to be making those decisions? Also, I'm going to sit there as an aside, talk about claims. And one of the claims is, unfortunately, matrimonial. And as Damien has pointed out, I was reading a statistic that during this period, they were thinking there was going to be more divorces in this period because he's spending more time at home. Now, I don't know if that's going to come to realization or not, but what you need to do is realize, hey, these are real claims that you need to deal with. Also, and as I think Damien pointed out, really good point, we've got to look at this. People have realized that set up their estate planning on the basis that certain monies they have. The stock exchange dropped by 40%. I know it's rebounded slightly, but if you have actually worked out your wealth and your estate planning based on a gift, for example, I'll leave my first $1 million to my children and then the balance to my wife, for example, then guess what? What if that $1 million is now only worth $600,000? You've actually then given your wife less. So you've got to make sure that it's actually considered. And if the will was drafted correctly, it should be by way of percentages, but sometimes that is not possible. And also, like I said before, COVID has brought these issues real home to roost. So you need to sit there and look at them. So estate planning. I always get asked what it is, and I always prefer to use a diagram to explain it because it's a lot easier. And I usually sit down and I have this diagram. I've got yellow, green, orange, and red. Now, whenever a client sits down to me, I don't need to explain the pre-capacity stage because normally they are of legal capacity by having that chat. But for completeness, I'll go through each stage. The first stage is you're born. And until you gain capacity, you're in the pre-capacity stage. Now, For intents purposes, I'm going to refer to that as 18 years, gaining legal capacity. Although that could differ because obviously you could have mental disabilities, you could have issues. And it could come, and so therefore it can actually be delayed. Also, then we talk about the with it stage. This is the green light. This is where everything, the world is your oyster, the master of your own domain, everything is fine. You make your own decisions. Then, unfortunately, lose capacity event. Then you hit the orange stage. You're not with it stage. Now, we all know with dementia and Alzheimer's that the green and orange can fade and go in and out. Now, for intents purposes, it's a lot easier for me just to refer to as a fine line, even though from a matter of medical perspective, I understand it doesn't. And then the last stage is death, which is pretty final. Therefore, when you're left with is the estate administration stage. So the question is, who controls in each stage and what document do you need, if any, to deal with it? Now, during the pre-capacity stage, you need a guardian. Now, normally you don't need a document because you were born and you have parents, and that's quite simple. They are your parents and they're your legal guardian. But you go through a divorce. Who is looking after them? You need to speak to Damien about making sure they've got parental orders. That could be the document. Or what if you die and you have underage kids? Who have you appointed as your guardian? So the document there for your children is your will. Now, then you deal with it stage, which is the green stage. Now, like I said, you are in total control of it. Now, you can optionally appoint someone else as your attorney to sit there and actually make decisions concurrently with you. You can do it in two ways. And the first is a power of attorney and the second is an enduring power of attorney. And they both kind of do the same things. They do the same things in relation to finance. But what happens is that the power of attorney can only deal with finances, whereas the enduring power of attorney can deal with finances and health matters. Now, in respect of finance matters, what happens is the power of attorney will come to an end once you lose capacity, whereas an enduring power of attorney will endure that loss of capacity and will continue until death. Now, you cannot, during the green stage, delegate or give concurrent authority to your health matters. You can only do that once you lose capacity. And then I'll move to the next stage, which is the losing capacity under enduring power of attorney. Those health matters then can be dealt with by your attorney. Now, if, however, you have the limited circumstance of an advanced health directive, and I won't be, you guys know a lot better than me in relation to that in relation to very limited circumstances like not feeding, no antibiotics, no hydration, you can make the actual decision for the doctor and tell the doctor what you want done. So that's why I put the decision making is by you. And the final stage is in relation to the estate, where it's your executor or trustee. And the document there that kicks in is your will. Also, what's called a binding death benefit nomination. And that document sends the money from your super fund into your will or whoever you designate, whether it be directly to a person or to your will. Then you can have other documents called statement of wishes, statement of directions. Now, they come under a lot of names. Things are memorandum of wishes, memorandum of directions, a lot of things. But generally what they are is just a statement saying what you would like to happen. And later on, I'll explain to you how binding they are or not. So I will cut to the chase. What is estate planning? Well, it's everything. It's from the date that you actually gain capacity until the end of your estate administration. And what you need to do is consider your asset protection at the same stage and look at your estate planning. Now, for you, a lot of you, like I said earlier, a lot of you will just be your will and your enduring power of attorney. For others, it will be a lot more complicated exercise. So when we talk about asset protection, what is it? And you'll see there on the right, which is the devil, which is all the bad things that can happen, and all the good things on the left. Now, I've put a big asterisk next to spousal claims because Damien has correctly pointed out that the measures that I put in place for you to protect against creditor claims and guarantee claims don't apply in the family court. You need to make sure you've got a good binding financial agreement in place, and that's where you need to speak to someone like Damien. Now, as Chris pointed out, negligence claims, they're going to be dealt with by insurance, third-party claims, insurance. Speak to someone like Chris to get insurance in place. Now, however, what I do is I cover about making sure that there's no contractual nexus of the person to the other claims for all the other points. So making sure you have a backup plan. So what forms part of your estate? Well, everything that's yours forms part of the estate unless you own it on trust or jointly. So really about estate planning is not really what forms part of your estate, but what doesn't form part of your estate. And the big one is assets you own on trust. If you own an investment property and you're the trustee, as for the family trust, it doesn't form part of your estate. If you own a joint bank account with your partner, it is not yours on your death. It goes to the survivor, and I'll explain that. Also, super and life insurance, where you are not the named beneficiary. They will go to whoever's named in for super, a binding death benefit nomination, or life insurance, whoever is the named owner of the policy. Trust assets, they are not yours. I put there the 80-year lifespan because under law, there's a law against perpetuities. Trusts can only live for 80 years from the date on which they actually conceived. They then must come to an end, unlike a company which continues indefinitely. Those assets do not form part of your estate. So what is tenancy in common? Really, it is the survivor takes ownership immediately before you die, like the nanosecond. So therefore, at the nanosecond just before you die, that asset, whether it be bank account, shares, property, vests in the survivor. Therefore, your will not dictate where that asset goes. Tenancy in common basically endures the death. So what happens is that it still remains yours. So therefore, it forms part of your estate and you deal with it. So the question is, why would you bother with joint tenancy? The big one is there's no need for probate in respect of that asset. What happens is that probate is the court process of getting it approved that it is your last will and testament. Assets aren't frozen. They can take 6 to 9 months to get that. Now imagine if that was a bank account, all the bank accounts are in your name, and the bank will not allow them access to the money for your spouse. That is going to cause major problems. A jointed bank account means that the spouse can continue to actually access those funds at the time that they are grieving. Also, if it's done very carefully, you can do it. It can avoid attack by third parties. If, for example, I own an asset with somebody, and then it actually is a joint tenancy, then what it can be is not subject to a family provision claim. Now, a family provision claim has nothing to do with the family law that Damien's talking about. It's a claim under the Succession Act against your will that that a family member or dependent has not been adequately provided for in the will. They can actually get the will amended to sit there and say what the court think it should be. If the asset never formed part of the estate, they can't attack that asset. So why tenancy in common? Well, you can choose where your asset goes. Now that could be extremely important with blended families. Use an example that you've married, you had children, you meet someone else who also has children, you remarry. If that you then own those assets jointly, it's going to go to the survivor, means it could go down their family line, not yours. Also, if it's under a will, tenancy common, you can give it under your will, which means you can put it in a testamentary trust. Now, testamentary trusts have very good protection for asset protection, and there are exceptions in relation to matrimonial, but if they're drafted very carefully, they can actually sit there and pass that test. So, what are testamentary trusts? Testamentary trusts are simply a trust that's established on your death. There's nothing magical about them. There's no mythical being. It is just a trust that comes into existence at that time. There are no costs of administering it until your death because they don't exist until you die. So unlike a discretionary trust where you have TFNs, you have tax returns, this doesn't apply until you get there. Now, what are the benefits? Hugely asset protection. Now, they can create massive protection for assets, and depending on the circumstances, I know Damien will be cringing with me, also if they actually in relation to spouses. Now, like Damien said, spousal claims are a different beast, and the courts have ridiculously wide powers to sit there and overturn them. But if they're not an appointer or they're not a trustee, then they don't have any control and they're not a contemplated beneficiary directly, then you can actually gain some protection there. Tax benefits. This is probably the best one. Children under 18 can be treated as adults. So rather than distributing $400 to them each year, you can distribute $180,000. Now that could be a massive benefit. Now, what are the negatives of testamentary trusts? Well, they cost more. I mean, to give you a guide, that's almost double the cost of actually a normal will. Depending on the terms, are you ruling from the grave? People always say, once you're gone, their assets deal with it. Or do you need to rule from the grave to protect those assets for your children or your spouse? And the administration costs. Owning assets in your own name don't cost anything. Owning in a trust will. but usually that's the same as a cost of a family trust. So what happens to these assets that don't form part of your estate? Well, for those assets that are controlled by your trustee, for a trust, they're the trustee. Now, under the trustee, there's normally a person with the power to change the trustee, which we refer to as the appointor. So whoever's the appointor is the most important person in a trustee. For those assets owned by a company, the directors control it. But the person who owns the shares can kick out the director at any time. So therefore, they're the ultimate controller. And super assets is whoever's named in a binding death benefit nomination. Or if there is no binding death benefit nomination, the trustee of that super fund. So how do you know they're going to do the right thing? The trustee of the trust, the shareholders, the appointor? The simple answer is you don't. The fact of the matter is that they're not your assets, and therefore you cannot dictate what they do unless it's a term of the trustee or the constitution. What you can do is sign a statement of directions or memorandum of directions, and like I said, they come by a myriad of names to stipulate the way in which you would like them done. But the fact of the matter is they are not binding in law. So you have to have a huge level of trust. So why do you do it? Well, you've got to weigh up one against the other. What's the importance of asset protection during your lifetime and potential tax benefits versus the risk of them running off? So what are the other documents you need? Well, review constitution, trustees, make sure that the appointors, make sure that all those documents are in order, and so therefore the assets go where you intend to. Make sure there's an enduring power of attorney in place, an advanced health directive, a statement of wishes, statement of directions. Make sure everything is bound, so therefore what you believe is your asset, and you find out, actually, I actually own an investment property on trust, actually goes in the manner contemplated by your will by proper documentation. So just lastly, let's talk about contact free. The big thing is physical signing of documents. Obviously, anytime you physically sign a document, it comes at a risk, but physically signing a document properly is the 100% proof, safe way to make sure that it's binding. Now, what we do as part of our firm is that we've got a 70-year-old lady who was too scared to actually leave her home to update her will. What we did is we arranged for her to actually drive into the basement. We went downstairs with 2 witnesses with sanitizing cream, sat there, passed it through the window, reread it, signed it. She stayed there, sanitized her hands, we witnessed it, then she drove off. Now, that enabled her to get what she wanted without the risk of actually knowing that she had COVID. Now, she's now a lot more comfortable at home knowing she's got all those things in play. If that's not possible, the legislation stepped in to sit there and try and assist. And what they've done is then from the 15th of May until the 31st of December, there will be, as you can actually do sign wills by video conference like this. However, it should be a last resort, because then it's always going to be, did they actually know what they're signing? Was the actual internet connection working? And you can always bring up things to attack, and you don't want that. You want this to be as certain as possible. So we're always recommending, even if you do it that way, get them signed immediately after once you can. And also the Titles Office, which is registry for all the land, has also stepped in and also introduced this audio-visual link for signing. I hope you find that very informative. If you have any questions, please do so and feel free to, and I'll hand you back to Tori.
Thank you for that, Anthony. Thank you all for participating in this evening's webinar. Okay, an email will be sent including a CPD link to log this evening's event, an inquiry form for all presenters which will include any opportunity to ask more specific state-related questions regarding your own situation, a PDF of the combined presentations, and a link to the event recording. As you leave this evening's webinar, you'll be given the opportunity to click on a link to an evaluation survey. Please consider completing this as it shapes what we have on offer. There will be an opportunity to suggest future events. Also, a reminder of the COVID-19 information via the button on the RACP website. This details all the work the college is doing to support and advocate for members. The website is www.racp.edu.au/news and events/COVID-19. Please also note that other webinars are being offered, and visit the RACP events page and look out for our emails promoting these. So that concludes this evening's event. We've just got a question come in. I think for Anthony, what about digital signing? Is that something you can answer now?
Yeah, look, it's very limited in relation to wills. Digital signing is very good for any document that's not a deed. See, the problem you've got under law is that an agreement doesn't need to be witnessed, and that can be digitally signed because you can't verify witnessing, whereas a will is effectively a deed. And so those actual amendments to the legislation are referred to are probably the only way you can get it signed.
Thanks for that, Anthony. So that concludes this evening's webinar. Many thanks to Anthony Harrison, Rhys Williamson, Chris Mariani and Damien Greer and the RACP team for a great presentation, and thank you all for joining us tonight. Please watch out for our email. Good night to you all.